Hula Dunya agus Falcha. Good morning, everyone, and welcome. This is the 12th meeting of 2020 of the Justice Subcommittee on Policing, and we have no apologies. The first item on our agenda is a declaration of interest, and before we begin, can I start by paying tribute to James Kelly for all his hard work on the Justice Subcommittee on Policing, and wish James well in any new role he takes on. I'm also pleased to welcome Rhoda Grant as a new member of the Justice Subcommittee on Policing, and I invite Rhoda to declare any relevant interest. Rhoda, please.
Thank you. I don't think I have relevant interests as such and would refer people to my register of members' interests, but just for information, I'm a Unison member, I'm a member of the Co-op Party, and I have an intern from CARE.
Okay, many thanks indeed, Rhoda. I have an interest to declare before we move on. In 2011, I was briefly a member of the Peace Appeals Tribunal. My election to Parliament meant that I couldn't proceed with the case, but I think, albeit that we'll not be discussing any historic cases or indeed any live cases, place that on the record. Now, agenda item 2 is a decision to take items 4 and 5 in private, which is a review of the evidence we hear today and consider our forward work programme. Are we all agreed? If you disagree, please indicate either on screen or in the chat box. Everyone seems happy with that. Thank you very much indeed. Agenda item 3 and our main business of the day is about police complaints. And it's an evidence session on the final report of the independent review of complaints handling, investigations and misconduct issues in relation to policing. I refer members to paper 1, which is a note by the clerk, and paper 2, which is a private paper. And I welcome our witnesses to the meeting, the Right Honourable Dame Ailish Angelini, QC, Chair of the Independent Review Group, and Ian Kernahan, Head of the Secretariat. And I thank the witnesses for taking the time to provide evidence to the subcommittee today, and invite Dame Ailish to make some brief opening remarks, please.
Thank you very much indeed, Convener, and good morning to you all. I have very brief comments to make at this stage because I think the report speaks for itself, but only really to thank the huge number of members of the public who participated in this, also in the number of police officers, and indeed the Police Scotland itself, and the Chief Constable and his team were duly cooperative and very helpful during the whole of the review. Also, PERC, SPA and COPFS equally were extraordinarily helpful and cooperative throughout, and I'm very grateful to all of them. As you're all aware, I published an interim report in May 2019, and I'm very pleased to see that considerable progress has been made on the recommendations there by Police Scotland, the PERC and SPA, and that's reflected in the report. And again, I think that there's a genuine real will in these organisations to effect change and improvement for the public interest. Thank you.
Thank you very much indeed, Dame Ailish, and I thank the witnesses who have provided written evidence to the subcommittee. It's most helpful. And can we, before we move to questions, can I remind members to indicate who the question is for, and to remind all attendees to wait just a moment for your microphone to be activated before speaking. Dame Ailish, with a significant number of questions, as I'm sure you would anticipate. Before we start, can I maybe just ask you, the committee's aware of the enormous task that it was to undertake. Can you provide a very general overview of the approach you took in carrying out the review, please?
Well, there was a considerable amount of research which had to be done before we could see any members of public, and really I had to acquaint myself with the whole system. I have been away for many, many years, since 2011. And therefore looking at the changes in law which have already taken place, the statutes, the regulations, etc. The production of the interim report was something which I haven't had to do before, so at that stage I was being asked to show my thoughts as they were developing, and any interim recommendations which needed to be made in that context. I think you should all be aware, obviously, from the remit that I was not looking at the COPFS because it was excluded from my remit. However, I have made some recommendations, particularly regarding delay and also regarding the role of the PF in there. so that because they clearly have an impact, and I understand that Her Majesty's Inspector of Prosecution will be carrying out a review of the complaints against the Police Division of the Fiscal Service this year, which I think would be very timely and fit in with this review that I've carried out. But so the interim focus was very much on structure and on looking at the structural issues before I met the members of the public. And the second section from there on was a number of focus groups, which I spoke to, had fantastic discussions with large groups of police officers, Federation representatives, and also members of the public and police officers who had been either the subject of complaint or had made complaints. That was very helpful, as well as a number of focus groups and community groups who represented particular parts of the community. One which was especially significant was NISAG, which is an advisory group to the police, which alerted me particularly to the fact that many new immigrants to this country come from states where policing is very corrupt and can be quite brutal. And there's a very significant lack of trust in police in many of these countries. But that in itself presents a challenge, because there is a rebuttable presumption that these communities have that therefore it must be the same in this country, and which it's not. And therefore there is a real effort required to be able to get back into those communities, convince them of the benevolence of the police in this country and the great good that the police do for the country.
Thank you, Dame Eilish. Our next questions are from Rona Mackay. Rona, please.
Thank you, Convener. Good morning, Dame Eilish. My question's for you. It's been widely acknowledged that the systems and processes involved in police complaints, investigations and misconduct proceedings are extremely complex. Can I ask how important you felt it was that the system was subject to such an in-depth review? And if you're confident that if the recommendations which you've made are accepted, they will lead the system to become less complex and more accessible, and sort of enhance confidence in the system for police officers and the public. Just as an example, some of the submissions we've had are very much suggesting that police officers should not be involved in policing the police and they should be taken out of the system. So if I could have your remarks on that, please.
Yes, well, it was complex, and it is of its nature complex, because we have, 4 organisations that have an interest in complaints against the police, and of necessity, that requires a map to be navigated, and you'll see that running through the whole report is emphasis on accessibility, not just accessibility for those who are IT literate, but for everyone, so that there is much greater humanity in the system, that people can speak to individuals, not required to email, and ensuring again that those who are disabled or those who come from minority communities are able to access a system which has been a challenge in the past. So that accessibility is something which is absolutely critical, and a very clear understanding. And certainly the police found some way in improving their website following my interim report, because it really, I described it originally as being like the wiring system for the Starship Enterprise at the beginning. If you had looked at, if you're a member of the public trying to navigate it, I think that it is necessarily complex because there are so many rights involved and because we put in the protections. But I do think that there is a real determination now to ensure that it's as simplified as possible. And for instance, the CAPD division of the Procurator Fiscal Service can deal with complaints of criminality directly. The public do not need to go near the police. That's one of the standing rights that members of the public have had for many, many years, but it's something which is not known. And therefore it's about making that notorious, making sure that that light is no longer under a bushel, and people realise that there is de facto an independent system for the most serious allegations that can be made. And therefore that is something which is made more accessible.
Thank you.
Point, Rona, I'm not sure if there's any follow-up.
Yeah, I just wanted to follow up with a question. maybe the question that I asked at the end of that question, police officers should not be involved in policing the police. Do you think that that's a good recommendation? And my final question really is, your final report contains 81 recommendations. Are there any in particular that you feel should be given priority? Are there any immediate measures which could be taken either legislatively or otherwise to improve the system? During a recent debate in Chamber, for example, a colleague on the committee raised the point of an action tracker on the Police Scotland website, and we've received submission signed by several stakeholders who very much support this. I'm wondering if I could maybe have your view on that, please.
Well, so far as the police, policing the police, I think there isn't a straightforward answer to that. That's a nice quote, because the reality is that they are employers, and there is a sphere of conduct where, as an employer, constables are in an office, so they do not have the normal HR system that you would have as an employee if you were in Marks and Spencer's, because it's an office. But there is nonetheless a need to manage and to train and support and to give example to those people. And that needs to be done at the management level. If it's a constable, it would be the sergeant or the inspector, and upwards as you progress up the chain. So that example, and I think the police need to have room to manoeuvre where the manifestation of mistakes or perhaps some minor bad behaviour is something which might be an indication of something that's wrong in that individual's life, that something's gone wrong, or maybe the beginning of mental health problems, or it could be there's a domestic crisis in the family, and there is a need, therefore, for the police to be able to have room to ensure that things are not escalated abnormally into a discipline system, rather than into what would in any other context be an HR system. And therefore, what I have said in my report is that I think the threshold for misconduct should be raised, and that there should be much more proactive management. The difficulty I had is I don't know that there are many have the full set of skills required to do that management, to be the mentors and to be able to change that. And I think that's a challenge for the police, to ensure that all those in these promoted positions have the capacity and the room to manage. And many of them are extraordinarily overburdened. There are very few sergeants in this country. Many of them have been removed from post. And I do think there is a significant need for an increase in the sergeant role in particular, that you have people of the right disposition who are people with very high levels of morals and are good exemplars to be able to manage. So there needs to be that room for what would be normal management. Beyond that, then, when you do move to misconduct, I do think that there is a real imperative to ensure that where something is of a sensitive or serious nature, it is not being investigated by the police themselves. And that's why I have pointed that out in the report, and I think that's a recommendation that's really important, where human rights are engaged, where there are allegations of ill treatment, inhuman or degrading treatment, or wrongful arrest, which is of a serious nature. And there's an example of a case which was particularly egregious, where someone was kept in for 4 days and it was completely innocent of the matter. These matters need to be independently investigated, as well as clearly matters such as deaths or very serious injuries. So there are levels of what might be described quality of service, and I think it's sensible that those are dealt with, but not by and you'll see I see in the report, not by, I think, the line manager of the individual, because the evidence I received was that from many members of the public, it was repeated that they did not like the line manager of the officer in question coming to their house. And they felt that there was a sense of emotional blackmail, however it's described, that they were told that he's a great lad, he's always, this could be the end of his career, this is not like him. And that type of conversation, they felt, may have been well intended, but actually had an intimidating effect on them. Therefore, that's why they wanted greater impartiality in the way in which it's dealt with. And I think that's why I have recommended that the front line, the Professional Standards Department, deal with these rather than the line managers, to give that degree of, again, impartiality, even in those matters which are not of the level that would bring them into misconduct necessarily, or into gross misconduct.
Thank you. Can I just one final thing. The action tracker on the website, is that something you would approve of?
Yes, absolutely. It sounds like an excellent idea, and I would very much support that. And of course, in terms of the priority, the recommendations, Rona, it really is now for Parliament and for the government to determine which they want to give priority to. And what I have provided this report after 2 years of study and research and meeting with a tremendous team of civil servants. And I introduced Ian Kernan, who's with me today, Paul Allen and Jenny Coltman. They were a fabulous team, but there's a tremendous amount of work that's going in clearly to make those recommendations, but I do think that they require considerable consideration as to where the priorities lie. And I should acknowledge, some of this will cost money, and we're in the middle of an international pandemic, so I'm realistic that the government and the Parliament have priorities which at this point overtake what is here. But nonetheless, I do think they are very significant, particularly in the devolved context, so that Scotland has a system that the community and police officers can rely on and is trusted.
Thank you, Dame Eilish. That's very helpful. That's me, convener.
Thank you, Rona. Our next questions are from Liam MacArthur. Liam, please.
Thank you, convener. Good morning, Dame Eilish. Good morning, Mr. Kinahan. Can I echo the convener's comments and thank you very much indeed for the work you put in on this very important subject, and also for sharing with the committee the interim report and appearing before the committee at that stage, which was, I think, very helpful for giving us a sense of the direction. One of the issues that was discussed then, in light of concerns the committee had heard, was around the categorisation of complaints. We'd heard examples of where assaults had been miscategorised as excessive force. There were perhaps even more egregious examples that were cited by the committee. Now, it was raised in the debate on your report in Parliament a couple of weeks ago by colleagues. I'd be interested to know what steps you believe Police Scotland and Crown Office have been able to take in trying to improve the way in which those complaints are categorised, and what, from your report, you suggest still needs to be done to address a situation which will obviously give concern both within the police force but also amongst the wider public as well.
Well, thank you for that. The Procurator Fiscal, the Senior Procurator Fiscal in charge of the complaints against the Police Division, very soon after my report was published, instructed that all excessive force cases should be reported to him for consideration, and that should happen within 48 hours. And that was done as a pilot, but it in fact has been maintained, and I think that is exactly what should happen. It's one of my recommendations, is that all allegations of excessive force or assault should be reported to the Procurator Fiscal for the Procurator Fiscal to investigate or to instruct the PIRC to do that. And I think it's important that the PIRC investigates these in order to give these serious allegations an independent investigation. In the past, they've very often been sent back to the police. I think it should be for the PIRC to investigate those cases. That, I think, is an important aspect. You'll see that Police Scotland quite properly carried out an audit themselves, and it was an excellent audit instructed by the Chief Constable, and that itself shows that there were still miscategorisations. I don't think there was any form of conspiracy for a second. It looks as if it's about training, because there hasn't been adequate training of the people on the professional standards, and I understand that that's now being tackled. But they need to have extensive training in dealing with these and identifying these cases. In addition to that, I've also recommended that the PIRC should carry out an annual audit every year of these cases to ensure that they are being properly categorised, and also contemporaneous audit, so that they can dip in through the computer system, look at what's been categorised. It's known as the Centurion system, but they should have access to that so that they can go right in on a daily basis and look at and dip sample cases which are being referred in. And I think that set of protections, the training in particular, the regular audit, and of course, when I did the interim report, there had not been any audit at that point by PIRC since 2014, I think it was. So it was a long time since the audit had been carried out, and that was because of resource issues that were described by the previous PIRC. So I think it's really important that that role of the PIRC is executed, and I'm absolutely confident now that given the this very significant improvement in relations among all 4 agencies, that was in itself a very significant obstacle to effectiveness and efficiency. That this new relationship that exists is very constructive, and I'm delighted to see a sort of sea change in the way in which they are now cooperating with each other to ensure that their respective and independent roles can be facilitated much better.
That's very helpful, and I think the point you make about the relationships between the various protagonists was one that featured very prominently, I think, at the point of your interim report. So it's encouraging to hear that those relationships are in a better place. I suppose one observation flowing out from that response is the level of consultation with complainers about the complaint they're making, and whether or not there were improvements that needed to be made there. I suppose whatever the process of investigating those complaints, the complainant should, one would assume, have at least a degree of understanding about the way in which that complaint is being categorised at the outset.
I think yes, I agree with you. The communication aspect is absolutely critical, and also communicating in a way that is appropriate for the individual. There are many people with mental health problems. There are people with significant disabilities, others such as autism, various conditions, which mean that communication can be a real challenge for both parties. And that's why the system can't just be one size fits all. It really needs to move away from the emailing. Email is fine for some people. That's what they want to do. I think this is an example. Virtual meetings can help, as well as ensuring that they take into account that people are nervous. That the practice of a police officer going out, the boss or the superior officer going out to visit someone in their house, in a police car and in uniform, doesn't take into account that for many people that's an event that they are embarrassed about. They're apprehensive to make a complaint about the police because they may rely on the police in the future and they're worried about the consequences of making a complaint. But to have an officer come out to your house, of course, all your neighbours think that you're about to be arrested, or there's been some domestic in the house. So it's something which that the police would just have to develop much greater emotional intelligence about how they deal with complaints and the sensitivity of that, and that even walking into a police station to make a complaint, which is another option, is a major thing to do for people. It's asking a lot. So it has to be as open and accessible, the full range of people, and reasonable adjustments must be made for those who are disabled, as well as for those for whom English is not a first language, who have mental health difficulties.
Thank you very much. Just if I could turn to the question of the code of conduct and the recommendation in the report that this be put on a statutory footing. It would be helpful to maybe understand the rationale behind that proposal, and probably any comments you might wish to make about the importance of that code of conduct in terms of influencing culture within an organisation like Police Scotland.
I think it's critical. The Police Act, the Reform Act, was put through, as everyone knows, on an accelerated basis. It was compressed, and I have to say that people have described the system as completely broken. I wouldn't actually agree with that. I think there's a lot of very good people working within that system trying to make it work, and in its early days. But what they have is a vast improvement on what went before, and certainly. But the code of ethics that I suggest should be is one which is already in existence, but making sure that is something which people really understand the significance of. It should be there. It should be the bread and butter of officers. That should be what they abide by. And I think putting it into the statute emphasises the importance of that, the importance of human rights. It's in their oath, which I think is a tremendous amendment of the oath. I do think the code of ethics is something which they should have in statute, and which I think that Scotland would be proud of having in the statute, which is the leading statute on policing in its country.
And from your conversations, have you met any resistance within Police Scotland to having that code of ethics on a statutory footing?
None at all. No one has. But probably we could just look at worthy words. It's got to be something which really permeates the whole service, every level of service. That's something which they're aware of and something which they actually subscribe to. And therefore it has to be a core part of the police induction training as well, because you can give fantastic training, but then someone goes out and there's someone who may not be a particularly good example is their partner or who's an influence, and they need to have the reassurance of this, as well as knowing that they can whistle blow and they can do that independently as well. And you'll see that I've made a recommendation that whistleblowing should be something that is capable of going to a third party, and recommend the PERC has that role. That would require, I think, reserve legislation for that particular recommendation. I think that's really important. So I think, yes, I think it would be a very significant statement by the Scottish Parliament.
Thanks very much, Dame Eilish. Thanks, convener, with further questions. Thank you.
Thank you, Liam. Our next questions are from Fulton McGregor. Fulton, please.
Thanks, convener, and good morning, Dame Eilish. I've got a couple of questions, and I suppose they're following on from answers or building on or allowing you to reiterate on answers that you've already given to colleagues. But in your report, you state the key stages of senior officer misconduct proceedings for both misconduct and gross misconduct should in future be removed from the responsibility of the SPA and made subject to consideration by an independent legally chaired panel. Could you outline it and build on why you think this change is necessary?
Yes, this is for senior officers. So this is the small group of assistant chief constables, deputy chief constables, and chief constable. And this develops further what was in my interim report, where I made that recommendation at the earliest stage. I sat in on meetings with the SPA, one meeting of the committee itself, and met with them. And it is actually, it is a rather small organisation for the huge responsibilities they have. But the one thing that came over when I was discussing matters with senior officers was the fact that they all know each other, because by dint of the very legitimate purposes of actually going in for meetings about strategy, IT, all the things which bring them in and out, they get to know each other very well, and particularly so because it's a small group of people. And so the idea that the very same people that are meeting on this daily basis should then form part of what needs to be an impartial panel, particularly because for a senior police officer to have any aspect of misconduct is usually a resignation matter at that level, or dismissal. So these are very serious decisions which are being made. I think it should be made independently, and that's why I recommend a further development is that all complaints against senior officers should go directly to the PERC, that the PERC should then determine what the nature of that complaint is. If it's an HR issue, if it's one which would normally be dealt with in a management, it should go back to the SPA for them to deal with it in the normal management way. But if it's one which would amount to misconduct, then that matter should be dealt with by the PERC and presented to an impartial panel, which consists of a legal chair appointed by the Lord President, a lay person, and a senior expert in policing who's not from within Scotland, because I think that's important again, because that senior group is close. And that brings, I think, with it both protections for the officers in question as well as for the SPA. And I think it's really important that particularly in the leadership group, that there is a real independence around that and professionalism around the investigation and and taking forward the execution of any misconduct proceedings. And I also suggest that the PERC should present the case rather than someone from the SPA or the police. So it really cuts the SPA completely out of that role.
Okay, thanks for that. I've just wondered, did you encounter any resistance to this proposed approach from anybody, but I suppose specifically the SPA or senior police officers?
No, I haven't. And the former chair of the SPA thought it was a good idea. She was quite keen on that, Susan Deaton.
Okay, excellent. Thank you very much, Dame Eilish, for those responses. That's me, Convener.
Thank you, Fulton. Dame Eilish, I have some questions now regarding deaths in custody, if I may, please. You've recommended that such cases should be dealt in the same timescale and with the same urgency as homicide investigations. I wonder, can you elaborate on why you think this is imperative, please?
Well, the death of an individual in police custody, if you think about it, you know, if you're in police custody or in a cell and you're arrested, you have all sorts of rights which immediately fall to you. You know, you have a right to have access to a solicitor who can come into the custody, etc. If the worst possible thing that you can imagine happens, you know, you die, then there are no rights for a solicitor that automatically transfer to your family. So that aspect of it is very important as well, is that the family need to have access to the same type of legal advice that the person who was in custody would have had to them, and that should be immediate and expert, so that they're able to get advice about what their rights are. A death in custody invokes Article 2 of the European Convention on Human Rights. It's one of the most serious and solemn provisions that there is in the Convention rights. Protect basically the citizen from the state. It's death at the hands of the state. And where that happens, it creates huge stress, not just for the next of kin, but also for any officers involved in these matters. Their life is suspended. If these matters go on for years, they can't work, very often become ill, and therefore it's imperative that these cases are dealt with for the benefit of all in the public interest, particularly if there's several officers involved in the case. They're not working very often during those times, or not able to work. When I say the same as a homicide, I'm talking about not about a 110-day homicide, which is a custody case. I'm talking about a year. A year is what you would have to indict a murder case in Scotland, and that is sufficient time for most investigations. We manage in the past, I'm sure that the Lord Advocate manages now, to get cases which are very complex and into court, murder cases and culpable homicide cases into court in that period by the dedication of resources to it. And these cases require that. They require that expertise and that resource because they are the most serious cases.
Thank you, Dame Eilish. Can I now come on to the issue of post-incident conferral amongst police officers who may have been involved in serious incidents and the potential implications for the justice process? There's a lot of interest in this, and obviously we're discussing things in general rather than case-specific terms. One of the submissions was from the human rights lawyer Amar Anwar, and if I can quote passages from that, if I may please. It goes without saying any forms would require to respect the fundamental right of the privilege against self-incrimination, as recognised by the European Convention. And the term that you may be familiar with, golden witnesses, crucial witnesses. He also, and I'm sorry to drop this on you, you may be familiar with the case, you may be not, but a case from south of the border, Casale, C-A-S-A-L-E. Casale, C-A-S-A-L-E.
That's actually that's not a case, that's the name of the author. She's a very learned judge or Casale, who wrote a report on deaths in custody.
Yes, indeed. I beg your pardon. Yes, it was the Casale review of the death of Sean Regan. If I can quote from that, please. From the moment it is operationally safe to do so, police officers involved should be kept separate until after their detailed individual factual account is obtained. Can you perhaps outline the implications of that not taking place, please, in the case of a death in custody?
I think I refer to Casale in the review I did for the Home Secretary on deaths in custody in 2017 and made a recommendation regarding post-incident conferral in that report, and I've made a similar one in the current report. The importance is something which takes place with civilian witnesses. As soon as there is an incident, normally what the police will do is try to separate so far as possible. If it's not operationally possible, then of course that has to be accepted. But if it's operationally possible and safe to do so, they will separate witnesses who are material witnesses to the events. And in order to get their unvarnished account fresh and not influenced by what someone will say. If you think about it, a couple in a car and the driver and a passenger, there's an accident. And if it's my case, normally I say to my husband, oh, you were going too fast there or whatever. He'll have a completely different view of it. And so you begin to influence each other one way or the other about that. So it's about your own recollection, making sure that it's not contaminated accidentally or otherwise. And it's the same with police officers. Although they're professional witnesses, they are subject to all of the other aspects that any eyewitness would have. And if they've been in a situation which is traumatic, their welfare has to be guarded. This is not about not looking after their welfare. There is a need to ensure that their welfare is supported. But it's also imperative in this context that the PIRC is there as soon as possible. And that's why I make recommendations that they must be at that scene as soon as possible. And I was concerned about the location of the PIRC in Hamilton, particularly for cases which take place up north. So if it is a death of this nature, they need to have a helicopter to take them up. They need to get up there quickly. And there is a need also to ensure that the police officers, so far as possible, people make sure that they're okay, but that they are not put in a place together where they can sit for many hours. And even though nothing nefarious whatsoever takes place in that context, for members of the public, it's like throwing a skunk in a room and telling people not to smell it. It's not in the interests of the officers themselves to be together. Because when I gave evidence, when I took evidence about this in England, it's a different context. The members of the Police Federation in England told me that there was no exchange of beliefs. This is in the English context. No exchange of beliefs and opinions, but they just would check facts. And that is precisely the point. The reason they said that was because they said that the CPS, the Crown Prosecution Service there, would come down on them like a ton of bricks if there was any discrepancies in their statements. But discrepancies are natural. That's the way things happen. And you don't have to have identical statements. So it's really important that there can't be any cloud over officers in that circumstance. And also they need to have individual lawyers in those circumstances too. It's not enough for the Federation to send one lawyer to represent a group of officers. There needs to be individual advice, and that they have an obligation to be, once they're identified as a witness by PIRC, provide a statement as soon as possible. And that's really important as part of their duty to assist in the investigation of the death. Therefore, what Casale says is, I think, absolutely correct. And I think it's something which is not an attack on police. It's actually in the officers' interests. Because later on, when someone cross-examines on the fact they were together over this period, then they will have a hard time explaining, if they have uniformity of views at that stage. There are some measures could be taken to mitigate it. Video-worn cameras throughout the whole process might help, but nonetheless, even there, the danger of groupthink or influencing, because not all people have the same interests. It's assuming that group do have the same interests. They don't necessarily, and I think it's really important for the future that this is clarified. But that is not to say that these officers should not be supported. Absolutely, they must be supported in these circumstances. That's critical.
And Dame Eilish, thank you for that. Is it your view that would require a legislative change? I mean, it would seem to be good practice. I'm sure most folk would accept that's good practice.
No, it would require a change of practice. It doesn't require a change in law, but the police in England have not implemented it. The College of Policing is still recommending the same process, and despite the fact that the IOPC there, the equivalent of the PIRC, has issued guidance to the police in England and Wales to the effect that I have just discussed, it's not being implemented, and I worry about it for the officers, and I worry about it for the public interest as well. I think I think there's a degree of naivety about it.
Thank you, Dame Eilish. Can I invite you to say a little bit more about, excuse me, the role of victims, so the deceased family and perhaps representation, and the view that they don't always feel that they're involved in the process. a similar situation that occurs with increasingly has been voiced by victims of serious sexual crime, where they think that the public interest and their interest aren't necessarily one and the same.
I think we have come some way since, when I started off in the early, well, the 1980s, early 1980s as a prosecutor. It's a very different culture about the public, and it was very paternalistic, and things were done for them and done to them in this context, and that has changed. It's continuing to change with the whole context of human rights now, where there is a rights-based culture which has been introduced. It's in our legislation. It underpins the Scotland Act. It underpins the Human Rights Act, clearly, and to act compatibly with that. And those rights oblige people in these circumstances, particularly if it's a death, to be able to participate effectively in the investigation. So it's not a right to be an observer. It's not just about people being kind to them and providing information. It's much more than that. They have a right to be informed, unless it operationally is inappropriate at that stage, and to be able to participate in a way which I certainly, as a young Deputy Fiscal, would not have recognised in a fecal acts inquiry. It was very much the Fiscal had responsibility for the interests of the public interest and the family. That's changed now, and I think that's a really important change, and I think it's a good change. But the ability of a family after a death to do anything, even if your intellectual agility is supreme, the grief and the shock, you're dazed, you need someone to be looking after the legal interests and rights that you have at that very, very serious point. You've lost someone who's a son, brother, whatever, a sister. You need to have someone at that point engaged, make sure that they are looking after the parental rights which are implicit in Article 2 of the Convention.
Okay, thank you very much indeed for that. Our next series of questions are from Margaret Mitchell. Margaret, please.
All right. Thank you, Convener, and good morning, Dame Eilish. And can I thank you for the tremendous amount of work that has gone into this very insightful, far-reaching report that, for me, absolutely addresses the concerns that the Justice Committee had about complaints when we looked at the whole issue in our post-legislative scrutiny. I wanted to focus a little bit on PERC. There's a lot of powers going to PERC, and the report recommends that the statutory function for preliminary assessment of misconduct allegations against senior police officers should be transferred from the Scottish Police Authority to PERC. Can you explain why this is important, and if you encountered any resistance? And in addition to that, the report also recommends that PERC be expanded to provide more powers, and some of these be removed from SPA and provided to PERC. Now, clearly, you've already indicated that a lack of resource stopped PERC carrying out its duty, if you like, to annually monitor the categorisation of cases. So have you had any discussion with the Scottish Government on the cost implications of these additional powers?
To answer your last question, no. And some of them would be resource significant, or may result in a transfer from one budget to another, an adjustment as well, depending on what the approach is to the implementation of these. So that will be for others to consider. And as I said to the convener at the beginning, I perfectly accept that at the moment we're in the context of a hugely challenging international pandemic with all the consequences which flow from that, and therefore the priorities will be for the Parliament to determine. But when it is determined, I think these are really important, because many of the people, the members of the public I spoke to, are very vulnerable individuals and have suffered for many years. And I think it's really important that we recognise that it's a real big deal to make a complaint about the police. It's not something which people tend to do readily, and therefore there is a need to have a system that is fit for purpose and fit for the future, one which can adapt. On the issue about the PERC, yes, it is. Was there resistance to it? No, I think I answered this earlier, and I said that the SPA and the chair of that had no difficulty with that. They recognised the fact that they are seeing these people, weekly for They may have coffee together or sometimes lunch, but they have meetings regularly about matters. And the idea that suddenly they have to be impartial in the context of a committee. And of course, I'm sure they could do that and do it properly, but it's about it being seen to be impartial as well as actual impartiality, particularly such serious matters as senior officers in difficulty. So far as the PIRC's powers, I do think, I said that people have described the PIRC as having been toothless. I don't think the PIRC was toothless. However, I do think there is a real need to strengthen the powers, the independent powers of investigation. And you'll see that I have done that. I've given the power to take over a complaint, to do that independently of any person and in the public interest, to investigate it, to reinvestigate it, rather than simply have what was a power of recommendation, which somehow wasn't always followed up or didn't hit the particular target insofar as making change. So I think this is a significant power that they will have, which will add reassurance and protection to the public. Also, significant other powers as well regarding wider thematic reviews, which I think are really important. Where something's coming up constantly, the ability to go in and do a thematic review regarding these matters, I think will be another. I think it'd be a great tool for the Chief Constable. And the thing can I say just about this whole thing was that there wasn't. You talk about resistance. There wasn't resistance. There was a real willingness for the system to develop and to change. And I made comments in particular about diversity, obviously, in the issues about racism and discrimination. And there is an executive, certainly in Police Scotland, that is absolutely focused on these issues and wants to take them not remotely defensive regarding them. And I think that that's what I experienced. And I don't think they were being insincere to me. I think that is genuinely what they want. I was extraordinarily impressed.
Yeah, I think there has been a change, and there does seem to be more cooperation between SPA, PIRC and Police Scotland over piece, and the submission certainly suggested that. We won't go into the SPF one, which I think wasn't really realistic and fails to grasp the importance of the recommendations, because for me there is a lack of checks and balances in the single police force as it now stands. I'm wondering, are there any legislative reforms, I know it will be for Parliament to decide, but that you consider could be implemented sooner rather than later, which would improve the complaint system in the immediate term? Because this isn't just the wider public, police officers themselves that are operating under a system that isn't fit for purpose.
Well, I do think there are a number of which I think are significant. I think the powers of the PIRC are really important. You'll see that I suggest that the PIRC, its accountability should change from the executive over to the Parliament itself, to the non-executive body. That's compatible again with the Council of Europe's expert on human rights regarding his recommendations. It should be to the legislative body. There should be a form of statutory board, again, to ensure that the PIRC is held to account for efficiency and effectiveness as well. I think that's really important, because the PIRC role sort of hovers there without any real accountability, as other ombudsmen have. And I think that's really important for that to be addressed constitutionally. And also that there is a need for, I think, 2 deputy commissioners, because there's a lot of law in what's happening. They don't necessarily have to be lawyers, at least one should be another lawyer. And what the fiscals were finding is that huge cases would be reported to them, but that the law hadn't been analysed sufficiently well in these cases. It's really important that element of it is there, despite the fact that there have been many checks. It wasn't distilled in such a way that it made the decision making important. So I think that's important. In terms of legislation, if there was an urgency, I also think that the resignation of officers in the context of proceedings where the proceedings are pending or about to take place, or indeed in the middle of them, should be able to continue. I think that's really important, and that already exists in England and Wales, of course, and also the capacity for a BARD and advisory list to be compiled and kept by the Policing College, which it would indicate where people have resigned in the course of disciplinary proceedings, and they would then be on the advisory list. which they can advise other police forces across the UK and particularly in England, Wales and Northern Ireland, so that there could be cross-information about individuals saying this person left in the middle of these proceedings and you should be aware of that. But a public list as well, where people have been found responsible for gross misconduct and have, or rather, for both that, but also whether they resigned in the course of those proceedings. I think that's very important.
So it sounds like there could be things that could be done in legislative reforms just now, standalone, that would immediately improve things. And I entirely take your point that it's for the Parliament and the will of the Parliament to decide if that is a priority. Just in terms of a kind of public interest test, in relation to the recommendation that PERC should have additional power to investigate current practice or policy of Police Scotland if the Commissioner believes it would be in the public interest to do so. How extensive do you think that should be, and how should it be applied?
I think it's something which should be done exceptionally. I don't think I think it would disrupt and could have an effect of impeding the important independence of the Chief Constable if the PERC was in and out, like a yo-yo doing these. And you also have a very important role of Her Majesty's Inspector Constabulary, and the current incumbent I've met, hugely impressive individual, and the work that they're doing is really important as well and cannot be remotely discounted. So you've got to get on with the job. They can't be constantly subject to reviews and audits. However, I think it is important where matters of significant public interest arise that the PERC can do that. And I think that's actually of benefit to the Chief Constable, because he may find it difficult to have the resources to do that, and to have the PERC come in and look at a matter in that way, or the HMIC is involved in another matter at that time, to be able to carry out a review of that nature. But it's not something I would see as being a regular feature. It's something which is exceptional.
Okay, yeah, I did forget to mention HMICS and the excellent work Jill Emery's been doing. Right, that's me. Thank you, Kavina.
Thank you, Margaret. Excuse me. Our next questions are from Shona Robertson. Shona, please.
Good morning. Thank you. My first question is to Dame Eilish, and it's about whistleblowing. In your final report, you state that the absence of a prescribed independent third-party person to whom whistleblowers and policing can report wrongdoing is a significant gap that should be filled, and that you go on to say that you think the PERC would be best placed to fill that role. Just to if you could say a little bit more on why you think an independent entity is required. We've touched on some of that during your comments so far, but also why you think that the PERC is the right body. Are you confident that individuals will view the PERC as being wholly independent? And just finally, just for the sake of time to wrap this up in one question, what steps could be taken to ensure that whistleblowers will feel confident in approaching the PERC with what could be very serious concerns? Thank you.
Thank you very much. Yes, that was an issue which was raised by police officers about whistleblowing, and although the Chief Constable has already given officers the access to a charity known as Protect, which can give advice on whistleblowing and counsel people through that. A really important provision for officers. They can't deal with it. They can't actually respond to it. So what you're needing is someone basically, an independent party with teeth basically, that can do something about it in a way which will still protect the individual in question. It's important, I think, the PERC is truly independent, and I believe that the PERC is. The reality was, when you're starting an organisation from scratch, you've got to find the expertise for investigation from somewhere. So, and understandably, many persons were recruited from the police, retired police officers, senior police officers. And as a result of that, there is still a substantial number of police officers in PERC, and you'll see I have a recommendation that should be something which is phased out. It can't be done immediately. They are very valuable members of the organisation and have a real expertise. However, the PERC requires to get their investigative expertise from somewhere other than the police, of course using police senior retired officers or officers from elsewhere as consultants as well. But that needs to be done, and indeed the IOPC in England has been significant progress on that, and I understand that will take place. It's not about making people redundant or dismissing people, it's about moving there. And I think that fewer police officers are there. And I have to say the perception that the public might have about that as being sinister, the reality is that the police officers, members of the police, consider those officers in the park as poachers turned gamekeepers, and therefore, that they are in fact truly independent in the way in which they approach these. Nonetheless, it's about perception and about protecting impartiality. So I'm not suggesting that the whistleblowing would go into some email box that's general. It would be a matter for the commissioner or one of the two deputy commissioners. None of these persons should ever be a former police officer, and that would be a specific role only to those senior officers. And I think that gives itself a real protection and assurance regarding whistleblowing. But I think it's really important that that source is protected, and I have no doubt that that independence would be executed.
Thank you for that. You mentioned earlier on about body-worn video cameras in relation to an important role in evidence gathering. I mean, in your interim report, you recommended that Police Scotland should accelerate its plans to expand the use of body-worn video technology. Can you just say a little bit more about how the use of such technology might impact on the nature and number of complaints which are made against the police, and also expand on the risks associated with the use of such technology? I mean, are you confident that Police Scotland has carried out due diligence required to mitigate those risks and ensure, again, that the public can have confidence in the use of that technology?
I think video-worn cameras are really critical for the future. I think, if you in 20 years' time, we'll look back and think we're all quite daft. We're still talking about them. That the technology will have moved on. They'll probably be weaved into their uniform or something at that stage, and they'll be much cheaper. You'll probably be able to buy them for 20 pence or something at that stage. But at the moment, the technology is still relatively new and it is dear, and that's obviously an issue. The government, there are 80,000 officers in England and Wales with video-worn cameras. I'm told by the IOPC that there has been a reduction in the number of complaints about police officers. I think it's one of the most effective ways of ensuring better behaviour on the part of those who are intercepted by the police, but also by the police. That everybody behaves better because they know the camera's there. It's very effective. I actually bumped into a group of police officers in the main street here in Oxford, and they all had body-worn cameras. So I actually took the opportunity to speak to them about it, and they could not have been more enthusiastic about it. They said it is amazing. They said you only have to point to the camera, and suddenly even some of the most obnoxious, loud people suddenly begin to behave, so it's a very good protection for them. The implications, obviously, for resources are making sure that they're robust enough, they don't have to be replaced constantly, and also the storage of them. And with digital storage, that will become less of an issue in the future, and the reproduction of it for proceedings. But it will result in more pleas of guilty in trials, and therefore you will have savings to the justice system. I remember the introduction of video evidence, CCTV evidence from the streets. So many of the cases which would have proceeded to trial are now pleas of guilty, because you have the CCTV evidence available for the court. So I think it's a really important. In America, the evidence as well, the research here shows that it has exactly that effect. I think it's a great protection for all, and I think it would reduce complaints.
That's really helpful. Just finally, Convener, you mentioned earlier on about where the priorities lie, given the challenges that the government are facing at the moment with the pandemic. They're not going to be able to do everything in your report all at the same time. So I guess my question is, what are the top kind of 3 things that you would urge the government to get on with quickly? Would it be the body video technology, or is it the powers of the park, which you mentioned earlier?
It's very difficult because there would be expenditure required, and so some of these could be done. Some of these could be done on a cost-neutral basis. So I think if that's possible, but again, I'm the author of this report. I think it's now for the Parliament, the government, to determine the priority you want to afford to these, but all I can say is I think the video worn cameras are a real source of protection for police officers, and I think that they need it in the 21st century. We have had so many tragedies occur, and I think that if I can give you an example, I attended an inquest in England, and it was the death of an individual who was shot by an armed police officer. And I sat through the inquest. The officer gave his evidence, and to be perfectly frank, he wasn't that impressive as a witness. I didn't think, first of all, he wasn't the best witness. If I had been the prosecutor in a trial, I wouldn't have been entirely thrilled at the way in which he delivered his evidence. However, they then played his video-worn camera, and it displayed just how terrifying this whole episode was. It showed just how justified his action had been, and the fact that he was exemplary in his conduct. And I think that was probably the most telling piece of evidence supporting this that I experienced at that time, was that this will really help the police, but I think it will also help members of the public, and I think it will also ensure that the public feel better protected in certain circumstances, knowing that there's this capacity for things to be recorded. We are living in an age where everything is capable of being recorded from mobile phones and from CCTV. I think it's important that the police have their own recording in order to protect them in the future.
Thank you. That's all from me, Convener. Thank you, Dame Eilish.
Thank you, Shona. Our next questions are from Rhoda Grant. Rhoda, please.
Thank you, Convener. Good morning, Dame Eilish. Can I turn to diversity and inclusion? And reading the report, it's quite sad reading, to be honest, because it looks very little has changed since the Macpherson report was published in 1999, and that's a long time ago. Do you think that those attitudes are embedded in Police Scotland?
I cannot answer that because I didn't see all of the members of the BME community, there are officers in the police, but there are 273, I think, BME officers in the police force out of 17,000 odd officers. It's a very small number, and that's why I made a recommendation that there should be a review carried out. And I think the Chief Constable's already accepted absolutely that he wants to do that. I don't think it's embedded in the sense that I think there is an executive and the senior officers who are determined to deal with this matter and passionately. And I don't think that for a minute is just synthetic or what they say. I think they believe it in their heart. And I think that there are many, many officers out there who be horrified at the assertion that there is racism and behave in a manner which is absolutely correct. However, but where there are pockets of it or where there is indeed unconscious bias, some of this isn't deliberate. Sometimes it's because people have not been trained or educated to understand the nature of discrimination. And therefore there is a need for that to become something which is absolutely understood, and that there's a zero tolerance for, so that even, and I describe it as Macpherson did, as the canteen culture, that these quips, which are sexist or misogynistic, sexist, racist, are not tolerated. And it's very difficult if you're sitting in a group of people who are all laughing at something to actually say, that's not right, that's not acceptable. And come into a culture and feel that being diverse, being a member of the BME is an exception. There is a tendency, and this horrified me when I heard this evidence, to feel as if you've got to blend in. We don't want people to blend in. We want a police force that is as diverse as our population. Scotland is welcoming to immigrants. It has a tremendous culture of that, but the reality is different for these people coming in, and I think that's something which we've really got to study. You talked about feeling depressed in reading it. I felt extraordinarily depressed after for many days after listening to this, because it came as much as a shock to me as it has to everyone else. But it's there, and it's not just regarding those who are from minority communities, regarding women and LGBT members, where they're still subject to inappropriate quips or treatment resulting from those features. And I think that it's absolutely critical that is not tolerated at all. And I know that the Chief Constable and his senior team are horrified, and I think they have a real determination to deal with it. So I have faith in that. I have to say, somewhat disappointed in the response from the Federation of not recognising this. I think that's what they said. The service they recognise. Of course, the majority of people will be behaving absolutely properly, but it is there. And it's important, particularly for the Federation, to get out there and meet these people and not simply refer them to the BME or minority organisations. They don't have powers of representation. But the lack of recognition of that is something that I find deeply worrying.
Okay, you talked about the independent review that you recommended to take place, and the Chief Constable has accepted that. Do you think that should be a one-off review, independent of the organisation, or does it have to be conducted on a number of occasions to see if progress is being made? I get the feeling from reading your report that this is more embedded than we think, and I think people rightly are horrified. But if it is that embedded within the organisation, I'm not sure that it can be changed overnight by one independent review.
No, it won't. But I think it's important to get in. I spoke to just a portion of that population. I think it's important to see many more people than I was able to, and I think thereafter it's about training and training again. It's about people consciously understanding and looking at their behaviours, and that has to be done through. It doesn't mean you have to go away to a college. It can be different times of remote learning, but also discussing these issues and bringing them into the open. Line managers, those who are sergeants and inspectors, they are absolutely critical in this. If their leadership doesn't actually display a complete zero tolerance of this, then others will not behave. They are really in important leadership positions. But I do really believe that the police force needs more sergeants. I think that the ratio has been depleted to such an extent that officers are relying on constables are relying on other constables for their role models, and the sergeants or the inspectors are so loaded with administrative work and other things which they've got to do. They don't really have the capacity or the headroom to be able to manage people or be role models in that sense. But if the role model is actually the source of the problem as well, then that's even more sinister. So there is, as you say, an ongoing need for every organisation, and it's not just the police, it's all of us. We've all consciously got to begin constantly thinking about these issues and how we treat people who are different from us, to ensure that we understand that they have exactly the same rights and they have to be treated with utter respect as well, and that it's just not good enough to dismiss people. The current Small Acts programme, series of plays, goes back to a period way behind. It would be lovely to think that was confined to the sort of life on Mars type, but what's really, really worrying is it's still there. It's still there, and it has to be absolutely flushed out.
How quickly would you want to see that independent review carried out?
That's I think a matter for the Chief Constable. I think he's indicated he wants it to take place urgently, and I'm sure he'll. I think it is. I think it's a really important matter, as soon as possible.
Okay, and just a quick final question. Do you think those attitudes get in the way of the police dealing with complaints within their own and externally?
Of course they do, because how you deal with the public is bound to be determined about how you deal with each other. If people are nasty or constantly sarcastic, or making humorous quips about people's gender or their sexuality or their race or whatever, people treat people badly internally. They're not going to be able to go out there and treat the public well, or if they do, it's superficial. It's not in their nature. So they've got to behave themselves. That's the bottom line. That's got to stop. and they've got to recognise it. It's not a case of picking people out and punishing them. It's about making sure people understand the perspective from the other person position and are willing to ensure that it doesn't occur. It can't be done in an atmosphere of fear. It's really got to be from the heart, and it's changing people's hearts and minds is very difficult. And some people you won't. But even if they do entertain that type of mentality, they can't express it in a way which is detrimental to the rights of others. And they shouldn't feel comfortable in behaving in that way in Police Scotland, which is part of a modern democracy that's moving forward and is progressive. And it is important that if we are talking a good game about being very welcoming to immigrants, we have to actually display that in our behaviours as well, and the police should be leading that. And I really do genuinely believe that they have the determination and the willingness to do that.
Yeah, thank you.
Thank you very much indeed, Rhoda. We have an additional question at this point from Margaret Mitchell. Margaret, please.
Thank you, Convener. Damian, although not part of the review, there are two recommendations relating to the Crown Procuratorate of Fiscal Service. I think you mentioned that in your opening remarks. Can you explain why these are important? And I think you confirmed there was going to be a review of the COPF by the Inspectorate. And I wanted to ask you specifically, because this is really so important, that do you think it's important that the Inspector who is head of the Inspectorate should not be appointed by the Lord Advocate as they are at present and report directly to him? And also the secondments have tended to be from within the Fiscal Service themselves, and these are people who will be returning to the Fiscal Service. And I can't stress how much this has come to the forefront, wearing another hat in my role in the investigation into the Scottish Government handling of complaints. It seems to me something that urgently needs looked at.
Well, I first of all, the issues regarding COPFS, obviously, I think the Lord Advocate is about to embark on a thorough review of how those complaints are dealt with. The first issue is about basically ensuring that the public are aware of a really important right, which is to go straight to the independent prosecutor and bypass the police with a criminal matter. So that if they've been the subject or allege that they've been the subject of a criminal matter, they do not require to go to the police. There is, in fact, de facto in Scotland, an independent prosecutor who acts independently of any other person in this section to deal with that. It needs to be blasted from every police station so that people are aware of it. There needs to be posters. It needs to be, available to the CAB, the Citizens Advice Bureau, and public places that the people are aware of that. And I think that's really important. Delays, another matter. Again, the longer these cases, and I've mentioned that, so I'll not rehearse it, is really important that those delays are addressed so that these cases can be prioritised. But again, the resource issue, I think the Fiscal Service recently had a refreshing of its resources, and then more staff have been added into this section. So I think that will help. But again, not sure to the extent to which that will actually deal with the problems which have been referred to. About the PERC and accountability to the Lord Advocate, the PERC's accountability to the Lord Advocate only exists apropos the role of the investigation of deaths and prosecution matters. So that line is critical because the Lord Advocate in that context is independent of any other person. So they are de facto reporting to the Lord Advocate matters of criminality. They couldn't go to anyone else in that context. So, but the complaints matters, complaints handling, like for instance, PC blogs like mud all over someone's carpet, or that they've been cheeky and obnoxious, they've failed to investigate things properly, time and time again. The complaints handling aspect, that currently the PERC doesn't have a line of accountability regarding that. So she gets pay and rations come from the executive, come from the Cabinet Secretary for Justice. There isn't an accountability there, and so it's important that that is sharpened up, and that's why I recommend that it should be directed to the Parliament for that purpose, and that's what's recommended elsewhere. But regarding the persona or the personnel being senior prosecutors, I don't think people who leave the fiscal service are looking for a career back there. I think that those people who have been appointed, the two, Kate Frame and the current Michelle McClure, very senior prosecutors, and of course it's a bit like you have someone who already has the skills base, basically, and inventing that, particularly investigative skills base in the Scottish system, is important. But there's no reason why it couldn't come from elsewhere, from people from different countries. And indeed in Dublin, I went over to look at their system. One of their commissioners is from America. And that's why some of the reasons that you pointed out, Margaret, I've also suggested that there should be 3 commissioners. There should be a senior commissioner and 2 deputy commissioners, and it should be known as a commission as opposed to the commissioner. Take away that so that it's collegiate in its thinking, and that's clear, and that those 2 deputy commissioners should not come from the same place as the commissioner. So it might well be in the future it'll be a person who's not from a prosecutorial background, but one of the commissioners is, deputy commissioners is, or whatever. So I don't think it's necessarily the case that will happen.
I'm sorry, I probably wasn't clear enough, Damien. I was talking about the Inspectorate of Prosecutions, and when we did our report, people hadn't heard of that at all. And just now, the Crown Procurator Fiscal are a part of the whole complaint system, and if there are complaints against them presently, the Lord Advocate appoints the head of the Inspectorate, reports go to the Lord Advocate, and people from the Crown Procurator Fiscal are seconded for a period of time and then go back to the Crown Procurator Fiscal Service. And it was that I felt that, in our current climate, things are happening, absolutely essential to look at.
The current HMI PS is, in fact, not from the Fiscal Service. Indeed, she's not.
No. I know it's
I'm sure the Lord Advocate would be open to consideration about how that person is appointed in the future, and whether or not it's a different process or not. But having seen previous reports from HMIPS when I was Lord Advocate, I can assure you there's no degree of sycophancy whatsoever. They were particularly harsh. But I do think that there's merit in what you say about the way in which they are appointed. But certainly, I don't think it's confined. Certainly, it's good that someone from outside on this occasion. But the former Chief Inspector, was absolutely fantastic, as is evident now. She is now being made the perk, and I have absolutely no doubt that she will be hugely successful in that role.
I don't think it's any criticism against the person, but the system under which it's reviewed, and more independence and reporting to Parliament. Thank you for that. That's really helpful.
Okay, thank you. We're coming towards the conclusion of our evidence session. Dame Eilish, I've got 3 questions relating to some of the written evidence we've received. If I may, please, and I'll do these in sequence. The subcommittee has received written evidence from the Scottish Police Federation and the Association of Police Superintendents, in which they suggest that your final report does not have robust evidence in support of many of its conclusions and recommendations. How do you respond to that, please?
I think that came from the SPF. I spent 2 years gathering evidence, met so many members of the public and police officers, and obviously carried out research. The assessment of the report is for others to make, not for me. I'm not here to defend it. I think it is as robust as it can be in these circumstances, qualitative in its nature. And again, disappointed in the defensiveness of the Federation. I think that there are real interests for officers in there in getting this out, and the defensiveness, I think, is just completely disappointing from the Federation.
Could I turn to a specific from the Federation, and I'm going to, they consider in the round the recommendations contained in the report, and I'll quote here, Dame Eilish, will return the complaints process to a more adversarial, blame and sanction-oriented process than before. Can you outline the discussions you had with the staff associations during your report? And was there any concerns relayed about this approach?
No, indeed. In my interim report, I made a recommendation that the senior officers should have a legal chair appointed independently by the Lord President and a layperson appointed by the Lord President and an expert in policing, and there was and that likewise gross misconduct panel should be also subject of an impartial legal expert appointed by the Lord President in those circumstances, but also so the complaint by the Federation at that time was there wasn't a layperson suggested for that, and I was happy to consider that and looked to the issue and or further and made that recommendation for the same reason. So it was to give those committees and those panels greater impartiality. Police officers hold an office and it is really important, like doctors, nurses, accountants, others, that the nature of the adjudication in the public interest should be impartial, and I think that's really important. The suggestion that it returns it to an adversarial, I'm not sure that that is remotely justified, because I think that the Secretary General of the Federation would agree with me that the recommendations I make is that the threshold for misconduct should be raised, and that indeed there should be much more in the way of mediation, the way of HR intervention in behaviours of police officers, and that things should not be, as I think it was described by a senior member of the police, escalated like flash to bang to misconduct, and that things were being escalated unnaturally so, and that is not in the interests of the force nor in fact of the members of the public, and that there needed to be more proactive management of people by those who are line managers in that sense. So in a sense, it's looking at diverting people away from that system at that bottom end and ensuring that it's proportionate. The adversarial aspect is used in a pejorative sense. I think it's really important. If you're going to be accused of something as serious as gross misconduct, it is really important, A, to the public, and B, that it's a thorough system, and that the person who's the subject of it also has the benefits of the adversarial system. Indeed, the European Convention on Human Rights itself has moved away from the inquisitorial system that it has to all parts of Europe because of the faults and flaws in those systems, to a more accusatorial or adversarial system. And with that comes greater protections, and I don't think that's a bad thing. I think it's a benefit, particularly where you have serious matters of gross misconduct. That's why I also suggest that they should be held in public, as they are in England and Wales.
People of my vintage will recall that the change from discipline to misconduct was to facilitate this more managerial approach, remove all the quasi-judicial terms. Does that suggest, Dame Eilish, that it's there's a fundamental failing in how the complaints process has been dealt with?
I think that there has been a problem with management, of personnel management. It's something that people in other organisations have to do, like breathing. I don't think it comes naturally, because I think the nature of the establishment of policing is one which is very much about command, line of command, and therefore interactions can be informal, but that in itself doesn't give rise to the sitting down and having a necessary conversation about someone and their behaviour and the way in which, and that's necessary, and that can avoid things escalating. If somebody is constantly late, or somebody is, you smell alcohol from their breath, etc. These are matters which require interventions at an earlier stage before they begin to manifest themselves in greater problems or behavioural problems. And I think that the skills base for that has to be enhanced within the police. That's really important, so that these cases are not necessarily escalated into misconduct, so you basically get rid of a problem. You have to deal with the problem before it becomes one which is severe. I think that's really important for officers as well.
Thank you. I'd fully concur with that. My final question, Dame Eilish, you largely covered in your responses to Rhoda Grant, and it was about we've heard evidence from SEMPER, from Scottish LGBTI police associations, and from the Scottish Women's Development Forum about the need for a culture change and the ability for people to speak up, and that's regardless of background. I'm sure you agree with that. I just wonder the extent to which misogynistic behaviour features as part of the overall problem.
Well, that is evident from the evidence I took from these associations, but also from individual witnesses and many officers still serving in the police force who made submissions about the throwaway remarks, the sexist remarks, or the treatment or the patronising attitudes towards them as women. There are currently, I think, 32% of the force are women. It's still a minority. And I think it is something, you know, in one case it was about the design, for instance, of equipment for men, and it was designed for men. So it can be things which just tend to suggest you're a slight nuisance. We've got to think in a different way. And it's also obvious regarding, for instance, the part-time working or arrangements which can be made to facilitate people who have children and where the mother is the primary caregiver. Again, that was difficult. It wasn't coming from the top where these systems were in place and these policies were available, but that line managers made it absolutely clear that this was just an encumbrance and that, you know, having those hours is something which it was just inconvenient for all. So those attitudes, if they are permeating in the line management of individuals, are very serious to the prospects of keeping some very, very valuable officers in the service more than a few years because they give up, because they don't feel valued enough, and because they happen to have a baby and that inconvenience of that. Many of these people will be in the service for 30, 25 years, and there needs to be a recognition that that support has to be given. And it's there in the policies, it's there at the top, but it's not actually necessarily seeing itself flow down to the coalface.
Okay, thank you, Dame Eilish. Margaret Mitchell would like to ask a brief supplementary. Margaret, please.
Yes, thanks. It was just on the culture. It seems to me in Police Scotland with these low-level crimes, low-level complaints and the misunderstanding type complaints, instead of just acknowledging that things could have been handled better, there seems to be a defensive kind of attitude. So I wondered if you felt the power of an apology, we have the legislation there, could be used more effectively to improve the service for all concerned within Police Scotland, save a lot of time, a lot of money and result in closure for all concerned.
Absolutely, and I write about that in the report, that many of the people I spoke to said that they didn't want the officer dismissed, they didn't even want them punished. They just wanted him to be told that that behaviour wasn't appropriate and to apologise for it, and that if they got that apology, that would have been the end of the matter. Instead, a whole sequence of events would take place. And they want a sincere apology, of course. They don't want something which is just to avoid any greater trouble. But if there is a sincere apology, and that's why I criticise the way in which police would write sometimes pretty legalistic, officious language, even when they were apologising, there was an absence of humanity in the way, and that has been tackled, as I understand it now, as well. That's really important, how you communicate and the sincerity with which you communicate. And doing that, I think we could see many more problems resolved. And that's what the public want. They don't want to see heads rolled necessarily in many of these cases, the quality of service cases. They simply want something not to happen again. Or, as one woman said to me, for that boy to learn that he's not going to get on in the service if he behaves that. So in fact, she was concerned about him and his service, that he should actually learn. And the thing about complaints are nobody welcomes a complaint. The reality is it's something that you're not necessarily or instinctively going to welcome. But there's a huge amount you can learn. It gives you a great deal of intelligence about how you're doing as an organisation. And the willingness of an entity to learn from complaints is, I think, a reflection of its maturity and its ability to adapt for the future. And I hope that this report that I've done will contribute to that, and that people will not be defensive about it. I'm delighted that the SPA and the PERC and the Chief Constable have all responded very positively, and I genuinely trust that these things will be taken forward, that Parliament will consider them, and that they can add to the effectiveness of policing in Scotland in the future.
Thank you. That would be a major change and a very positive one.
Okay, thank you very much indeed. Dame Eilish, that's the end of our formal questions to us. Before ending this part, is there anything you would like to add by way of closing remarks at all, please?
No, thank you. I think I've said quite enough.
Okay, thank you very much indeed. Also, thank you to Mr. Kernahan for coming along. This was our first evidence session on the final report. We are to hear from the Cabinet Secretary for Justice in February and on the Scottish Government's response to the report. The details of that session and how to submit evidence will be published on our website shortly. I thank the witnesses for providing evidence at today's meeting, and that concludes the public part of the meeting. The next meeting of the subcommittee will be in January, when we will hear from Police Scotland about the implications for policing of the United Kingdom's withdrawal from the European Union. In the meantime, any follow-up scrutiny issues will be dealt with by Taurus Warners, which is always be published on our website. As previously agreed, I will now move the meeting into private session. Many thanks.